when two people are alive or one person, doesn't matter, you create a living trust. The living trust, basically, you can pretend it's a box and it has all your belongings and your assets in it. And you put everything inside this trust while you're alive. And this trust now can, own this property. And this property usually is all assets, including real property. So once you make your living trust, you put everything inside of it. That could be your house, jewelry, cars, everything. To fund the trust means you have to now create a grant deed that will now say, I'm the owner of this house personally today, and now I create a grant deed into Martha's living trust, okay? If something happens to me tomorrow, and I have, let's just say, 3 children, and I say in my trust, I give directives that all my children equally obtain an equal share of whatever's in this trust, or whatever I want to give them. It could be one gets the car, one gets the bank account, but they all split the house. Whatever you want to give to people, you put it in this trust and you give a directive. So if something happens to me tomorrow, this trust governs the directives, my choice of who I'm giving my things to. So I created this while I was still alive. So now you take this document and you're able to do everything with this document. It's like a grant deed or a power of attorney kind of thing, right? So this now governs and allows the people that inherited from here to do as I directed, right? And accept. So one person usually is assigned to be the successor trustee. That means that if there's 3 children, one of those children will be able to take this trust and liquidate the trust, right? And say, okay, so Martha wanted it to go to A, B, and C. She wanted the house to be split between 3 children. So now you take this property, this document, and you go to an escrow company or whatever, and you sell the property. You have the right with this document, as long as the trust is funded. In other words, when you were alive, I executed a grant deed into my trust for the property.
Who holds a trust deed? When you do a trust deed, who holds it?
Nobody holds it. What happens is when how I said I execute a grant deed, transferring the property into the trust. So now when you look at the title of my house, it's not gonna say Martha. It's gonna say the ABC Trust owns this house, not Martha.
Oh.
So now the person named in the trust, the successor trustee, is the person that has the authority to sign. Okay? But in many occasions, what happens is you have the person in charge doesn't comply with the duties that they're supposed to comply with. In other words, the successor trustee A was supposed to give the assets to A, B, and C. Right. So you have to give it to them. But the successor trustee sometimes can be spending the money because they have authority, right? They can go liquidate the bank accounts. So sometimes they're spending the money and not giving the money to the other people. Mm-hmm. And they do this sometimes because they're family usually, right? So they say, my brother's not gonna do anything. My cousin's not gonna do anything. So they take advantage and they don't distribute how they're supposed to. So people sit waiting around for the money because the other sibling or whoever's in charge is not doing their job. So now you have to demand accounting and you have to demand that they distribute what's owed to them. So many times they will go and ask over and over and over again, hey, give me what's mine. Mm-hmm. And the person will say, later. And then they never do it. So now this person will have no choice but to take them to court. So you hire an attorney. Usually though, the attorney, for example, our office, before we go to court, because court takes time and it's expensive. So we first start by sending what's called a letter of demand, saying, hey, you person, you need to give me an accounting because we represent this person, and you need to give me all the assets that belong to my client. And if you don't do it, I will force you through court. Mm-hmm. And then, then that's when things get sticky, right? Because now people have to act on a request of an attorney. So that's usually what happens when people aren't being given what's theirs in the trust, because most of the time, because it's family, someone's taking advantage, right? So
But what's happened with will? Why it's living trust is more important than will?
it's not more important. It's the problem with a will is that you don't have any power when the person dies. It's just a paper saying, and the person can write it on their deathbed. They can be in the hospital and say, okay, I want to give, if I don't leave the hospital, I want to give my house to Joe.
Mm-hmm.
And so this paper has no power because this is not recorded anywhere. It's just a paper.
Mm-hmm.
So even though the document is, let's just say, even, you know, and by the way, a will requires 3 witnesses. So if you, because, you know, even if it has 3 witnesses, even if it has a notary,
Wow.
it still doesn't have any power because a will is not it's not an entity that can own a house, only a living trust.
Mm-hmm.
So a living trust is like a person, like not a natural person, but like a corporation, for example, right? A will, you can't go record a will and say, oh, this will owns the house.
Mm-hmm.
A living trust is the only thing that can hold the asset.
What is probate? Probate.
So a will has to be probated. So what is probate? If you have a will, somebody left a writing, it could be any paper, typed, handwritten, witnesses, even no witnesses. And you bring the document to the court and you say, court, I want to open a probate because somebody left this will. This will has no power at all. It just has somebody's statement, right? And the statement can say whatever. I give my car to my dog, I give my dog to my neighbor, whatever. So you have to now take this document to the court, you open what's called probate. And the court will read the document and say, okay, well, who are the next of kin? So this document might say, this person said she wants to give her house to the neighbor.
Mm-hmm.
But the court most likely is not going to act on a document like this because it's basically, even though, and again, it's all discretional, the judge will look at the facts behind the will, and if it makes sense, then they can accept it. But it's still up to the court, it's up to the judge. But in most cases, because there's a will, they have to inspect it, they have to decide if the judge feels that this will is going to be acted upon. And if not, you're considered to die intested. So that means dying intested means you have no will. So the automatic next of kin get what they're entitled to. So you of course start with parents, children of the children, and
Yeah.
so on and so forth.